Welcome to Public and Private International Law, Chapter 9, Part 1. In this lecture, we will be delving into international commercial dispute resolution, and the main focus will be on international commercial arbitration. If you are doing business internationally, there are many reasons that can lead to disputes. One of the parties may fail to perform correctly, or the parties may come to disagree on the meaning of what they had initially agreed on in their contract, or suddenly the parties may be faced with an issue that is not regulated at all in their contract because nobody had imagined it ever could arise. It's not surprising that disputes are very much part of international business. And you better prepare for such events in advance. Suitable mechanisms that allow for disputes being resolved in meaningful ways are crucial for business success in many business transactions. And this is what international commercial dispute resolution is about. Here you have the program we will be going through. In addition, we will also try to find answers to a number of questions I'd like to submit to you. First question, how good an alternative is alternative dispute resolution, ADR? What is more efficient, litigation, arbitration, or mediation? Second question, if you opt for arbitration, is it better to go for an ad hoc arbitration or an institutional arbitration? Third question, what do we understand by lex arbitri? Question number 4, how challenging is it to challenge an arbitral award? Let me now turn to the first point in our program, the main options you have when it comes to international commercial dispute resolution. There are mainly 3 dispute resolution mechanisms that are used to deal with conflicts arising out of international business transactions: litigation, arbitration, and mediation. Litigation means filing a lawsuit with a state court. For the state court to be competent to hear the case, its jurisdiction has to be established. And for cross-border transactions, this has to be done on the basis of the relevant private international law rules, as we have seen earlier this semester. And of course, there can also be a choice of court made by the parties, for example, by means of a choice of court clause in the original contract between the parties. An alternative to litigation is arbitration. Here, the dispute is referred to an arbitral tribunal instead of a state court. This is achieved by means of an arbitration agreement between the parties, for example, by an arbitration clause in the original contract. The arbitral tribunal consists of 1 or more, often 3, arbitrators. A third option is mediation or conciliation, based on a mediation or conciliation agreement between the parties, and this often takes the form of a mediation clause in the original contract. Mediation means that in case of a dispute, a mediator is mandated to help the parties avoid unproductive legal battles and focus on finding an amicable solution to their conflict, ideally even some kind of win-win solution. The 3 options can be categorized along different criteria. The first criterion relates to decision-making power. State courts and arbitral tribunals both have the power to render decisions that are binding and enforceable. In contrast, a mediator lacks decision-making authority. A mediator can only suggest potential solutions to the parties, but has no power to end the dispute by rendering a decision. In order to end the dispute, the parties need to reach an agreement. Another distinction is between litigation, understood as the regular judicial resolution of disputes, and the alternatives to it, namely arbitration and mediation. This is what we call ADR, or alternative dispute resolution. Today, ADR plays a most prominent role, especially in international business. I'm sure you remember this case we discussed before in the contexts of private international law and international sales law. The case involves XSA, based in Yverdon, Switzerland, and Y Limited, based in Jaipur, India. XSA sells a machine to Y Limited for a price of $5 million US, but Y Limited refuses to pay, saying that the machine doesn't function properly, which according to XSA is not true. Now, assuming that XSA wants to sue Y Limited in order to recover the sales price of $5 million, what exactly are the options? Of course, XSA could file a lawsuit with a court in Switzerland or with a court in India, provided that the jurisdiction of the Swiss court and of the Indian court can be established. But what are the problems with bringing the dispute before state courts in Switzerland or in India? And could ADR possibly offer some advantages in our case? As far as the litigation options of XSA are concerned, a first option is a lawsuit in Yverdon, Switzerland. But as we have seen 2 weeks ago, this leads to an enforcement problem. Judgments of Swiss courts are not enforceable in India. Another option is suing Y Limited in Jaipur, India. But this doesn't look like a great option either. Even though India has a sophisticated court system with highly qualified judges, Indian courts are known for having huge backlogs, which means that litigation can take years or even decades. Following a lawsuit in India, XSA would most likely be stuck in court litigation for many years before having a chance to recover the sales price of $5 million US. So shouldn't XSA think about alternative ways of dealing with disputes? And one of those alternatives is arbitration. Could that be better in this case? Which brings us to the next point in our program: different types of arbitration and various arbitration institutions. For this, I invite you to follow me into the next podcast, Chapter 9, Part 2.